Are there any unresolved legal issues?
I think the landscape continues to change very, very quickly, right? Just yesterday, President Trump signed an executive order governing, or at least purporting to govern, sort of the NIL landscape in college sports, right? The fallout from that executive order, if any, will be certainly something to keep everybody's eyes on, right? The student athletes as employees discussion is a legal issue that I think we will see come to some sort of a head over the next several years. We've got the SCORE Act currently making its way through our legislative body. There are a lot of, for example, immigration and international student athletes that have questions, and pretty significant and very timely questions about the ability of those student athletes who are here on particular visa categories. Are they eligible to receive these payouts from their colleges or their universities, or will the fact that they are on the same roster even as student athletes who are receiving dollars in exchange, in theory, for their NIL, right? But maybe because they are on a football or a basketball or a lacrosse team, will that jeopardize their immigration status? Will it jeopardize, the allowance or the retraction of their visas? Right, as we see, an outsized focus on immigration, and an outsized focus on NIL, where I am not seeing a ton of intersection, at least from the decision makers, right, the people with the ability to enact and implement change, is the intersection of immigration and the new NIL ecosystem. Right, so I think all of those are new and emerging and very timely issues. But I also think, right, sort of harkening back to Title IX as a whole, right, NIL is just a portion of Title IX compliance. Title IX covers every aspect of a student athlete's experience. It definitely, right, applies to the provision of NIL dollars and related benefits, right, publicity and students, abilities to market themselves and co-brand with their universities. But Title IX, even taking NIL out of the equation entirely, continues to apply to things like the provision of gear and equipment and supplies, right? Student athletes care a lot about how well outfitted or how poorly outfitted they are. And they're looking across the aisle, your men's teams and your women's teams, to see what everybody else is getting when their gear drops at the beginning of the school year. Title IX continues to apply to things like we talked about earlier, the methods and mechanisms of team travel, right? Scheduling of things like games and practice times, right? As your men's basketball team always playing at 7 p.m., with the women's team having to tip off at 4 p.m., for example. Right? We're continuing to look at things like athletics facilities. Our football and men's and women's basketball practicing and playing in state of the art, really technologically advanced, gorgeous, aesthetically pleasing facilities, while gymnastics and volleyball and perhaps swimming are practicing and competing in really old, rundown, mold infested facilities, right? Title IX continues to apply to all of those areas as well. And I would caution athletics administrators in particular to not lose sight of the other portions of the administration of their athletics department that Title IX requires to be done in a way that does not discriminate against male or female student athletes.
How are lawyers and courts preparing themselves or are prepared to handle these matters? As you know, a lot of legal precedent is based upon existing cases or past cases, and it would seem that might be a little difficult and play into how these matters are handled.